And can you, Mr. Logan, adjust that screen in front of you? Just bend it up a little bit so Mr. Apt can see. There you go. Thank you. All right. Ms. Rivers, are you ready?
Yes, I am. Good morning.
Good morning. So are you ready, Ms. Dilligard?
Yes.
You are. Excellent. Okay, let's go on the record. This is position 3 on our trial calendar. State versus Logan, 22 SC 185229. Mr. Logan is standing here in court. Mr. Apt, his lawyer, is appearing virtually, and Ms. Dilligard is here. Mr. Logan, before I let Ms. Dilligard take over the proceedings, I need to get on the record that you are okay moving forward with this plea with Mr. Apt appearing virtually. You have a right to have your lawyer right next to you. Virtually, he's next to you, but you can't just lean over and ask him a question. You all right with that?
Yes.
Okay. Will you let me know if at any point you want to speak to him privately?
Yes.
Because if that comes up, you can just step outside. I'm sure he can give you a phone number and you guys can speak privately. I also need you to let me know if you've just got a general question that doesn't need to be confidential so that either he or I can answer that. Will you do that?
Yes.
Yes. Okay. When you're ready, Ms. Dilligard.
Mr. Logan, please raise your right hand. Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true and correct legal name for the record.
Keandre Deshaun Logan.
Mr. Logan, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not been given to?
No.
How old are you and how far have you gone in school?
23 and 11th year.
Can you say how far you've gone?
11th grade year.
11th. Okay.
Do you understand that you have been charged with the following offenses? It's 1 count of armed robbery, count of aggravated assault, 1 count of aggravated battery, false imprisonment, and possession of a firearm during commission of a felony.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charges in this indictment against you, including the facts and circumstances related to those charges?
Yes.
Would you like any more time to discuss the case with your lawyer?
I don't know.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and any and all defects in the indictment for purposes of the plea?
We do.
Mr. Logan, do you remember having been arrested on these charges?
Do I remember being arrested for him? Yes.
Has your attorney advised you of the minimum and maximum sentence for which you are pleading guilty to today? So the armed robbery, which we're reducing to robbery, the range is 1 to 20 years.
Yes.
Aggravated assault is 1 to 20 years. Aggravated battery is 1 to 20. False imprisonment is 1 to 10. And possession of a firearm during commission of a felony is 5 years consecutive.
Yes.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is to reduce the armed robbery to robbery pursuant to OCGA 16840. This total sentence is 10 to do 5. And then the 5 for count 5 is probated but suspended. Does that make sense?
Probated or suspended?
Suspended.
Suspended. And that's consecutive to the whatever the
10
one of
serve.
yours is going to be 10 serve 5 and then it's plus 5 suspended.
Yes.
Okay.
And the conditions is no contact with the victim, no contact with any of his co-defendants, and a stay away from the incident location.
Okay.
Is that your understanding of the recommendation?
Yes.
You understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximal possible sentence on each charge?
Yes.
Do you understand that if there are multiple charges which you're pleading guilty to today, that the court has the right to run those sentences consecutively?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Logan, how do you plead to the reduced charge of robbery, aggravated assault, aggravated battery, false imprisonment, and possession of a firearm during commission of a felony in indictment number 22 SC 185229?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
And do you understand that for a felony charge, you only have 4 years from today to file a habeas corpus petition?
Yes.
Judge, if this case were to proceed to trial, the evidence would show that on July 19th, officers responded to a robbery scene where the victim, Cullen O'Gara, Ogara, was found in the back of an ambulance after his neighbors called for help. The victim stated that he advertises on social media that he sells clothing and sneakers to potential customers. A few potential customers came to his house to purchase those sneakers. The victim had coordinated with one of the co-defendants, Charles Duke, to come to his house and to purchase and to look at the sneakers for potentially purchasing them in the future. Defendant Duke, Logan, and the other co-defendant, Mr. Grulon Panigua, who's already pled guilty in this case, came to his house, but they instead refused to accept. He did not accept payment over Cash App. That was the way that they were trying to pay. There was a disagreement, and then the defendants took out a firearm and zip tied his hands and his feet. They pistol whipped him, and they left with $15,000 worth of clothes and shoes, the victim's cell phone, and some cash from his nightstand. The men also told the victim not to call the police because they knew where he lived, and they left in one of the defendants' cars. They were able to get the license plate, track that to one of the co-defendants. That co-defendant then gave a proffer in the case implicating the other 2 co-defendants. I believe the last co-defendant is in judicial hold at this time.
He is AWOL.
Yes.
Yes.
And we are all looking for him. But all of this occurred in Fulton County, Georgia. I have had the opportunity to speak with the victim multiple times. He's comfortable with this negotiated plea. I expected him to maybe show today, but I don't see him. But otherwise, he is comfortable with the plea, and he's happy with the way that the case has been negotiated.
And can you tell me, we will have a stay away from the incident location. That would have been at the time his apartment, or, I mean, his address can remain confidential, but I'm wondering if you want to just have a no contact with the victim.
Let's just do a no contact with the victim.
Okay, we'll do that. All right. Are you seeking restitution?
We are not from this country.
Okay. Good morning, Ms. Jackson.
Good morning, Your Honor.
How are you this Thursday?
I'm great. Yourself?
I'm feeling a little tariffed, but that's just me. If you would share with me any criminal history information you've got on Mr. Logan, I'd appreciate that.
Okay. There are 2 cycles. The last arrest was February the 6th, 2025 in Gwinnett County for possession of Schedule 1 controlled substance and a DUI. There was no disposition for that arrest and there are no convictions listed, Your Honor. Nothing in addition.
Can you give me that date again?
Yes. February the 6th, 2025.
Interesting. Okay. Thank you. Mr. Apt, I'd like to hear from you about Mr. Logan, this case, and how it didn't hit our radar that Mr. Logan got arrested in Gwinnett. I guess he got a couple bonus months to be out and about.
Well, Your Honor, I'm not sure I'm going to be able to speak with great knowledge about the Gwinnett matter other than to tell the court that there's no disposition of that case. And, you know, there was never a motion to revoke his bond. So he's still presumed innocent in that matter. He does not have any prior felonies. I don't think he has actually any prior criminal history of any kind other than that pending Gwinnett case. So he is first offender eligible. And he completed the 11th grade. He was employed full-time, Your Honor, with Amazon. But when this incident happened, Amazon initially let him keep his job, but there were obviously, we've been to court a few times and they were not all that thrilled with the court schedule. So they had to let him go. He does have family that's present in court. I know his mother is here with him. And I've been in constant communication with my client and his mom over the last several years about this case. And we're humbly before the court, asking the court to accept the negotiated plea. I don't know if the state is going to oppose first offender, but he's eligible. And so if the court would entertain that, I think that would give Mr. Logan a second chance to, make something of himself and do good in the world.
Okay. Thank you, one, for your continued and persistent representation of Mr. Logan. I know this case overlapped with another case of yours that consumed much of your time, but you, Mr. Apt, made yourself available when we needed to handle certain things with Mr. Logan's case. And so hopefully he appreciates that as well. What are your thoughts, Ms. Dilligard, about first offender?
Judge, through negotiations, there were some other factors that Mr. Logan declined, and because of that, we had a conversation that we were not going to be consenting to. We would be opposing first offender. I do also want to highlight for the court that it's this defendant that the victim said is the one who actually pistol whipped him, which caused him to have to get multiple stitches in his head. So the state would be opposing first offender because of that.
Okay. Mr. Logan, you don't have to say anything at all, but you get a chance to be heard as well if you want. You can say, look, my lawyer said what needed to be said. But if there's anything you want to add, or if you have any questions about anything we discussed, I'm happy to try to answer those questions.
No, I ain't got none.
Okay. You got any idea where Mr. Burkott Dukes is?
Who that?
The third defendant?
Oh, no.
Charles?
I don't know none.
Don't know nothing. Okay. All right. Mr. Logan, this may seem like a tough outcome for you, but the state's agreement to reduce the armed robbery to robbery is pretty significant. I'm sure Mr. Apt told you a lot about this, but armed robbery has a mandatory minimum 10 years. And the sentence that you've negotiated, if I go along with it, is only 5 years in custody. Almost as important, those are parolable years. Whatever you got under an armed robbery sentence would be they call it to the door. It doesn't matter how great you did while you were in custody. You'd serve every day of that sentence. But robbery and these other offenses to which you're pleading guilty are parolable. That doesn't mean you'll get parole. I don't want you to leave here thinking, great, I'm out in 20 minutes. But given your lack of criminal history, assuming that you stay out of trouble while you're in custody, you will be someone that the parole board will be looking at, and they couldn't look at you at all if it was armed robbery. So you're young, and a 5-year prison term probably seems infinite, but Mr. Apt has negotiated effectively on your behalf. First offender. Has Mr. Apt talked to you about first offender?
Yes.
Okay. Tell me what you think first offender does.
Well, honestly, I don't know. I ain't gonna lie. I just knew about the other deal. I ain't trying to take that.
Okay.
I don't take that. I'm just gonna take the time.
You just want to do what you're doing.
Yes.
Your Honor, in full disclosure to the court, there was a negotiation for even less time where the state was going to consent to first offender, but it would require testimony. And and just to let, I know the court doesn't want to get involved in that, but Mr. Logan has a family member who did exactly that a few years ago in Fulton County, who cooperated against his co-defendants. And then it's Mr. Logan's cousin. And then subsequent to that cooperation, he was murdered by the co-defendant. So he's very hesitant, and that's why he's being quiet and not very verbose today. But I assure the court, he understands. I've gone over what first offender treatment does for him, the benefits and the burdens. And we are requesting it. I appreciate that the state is opposing it, and I understand why.
Right. Okay. I understand that. And Mr. Logan, I'm sorry for you and your family's loss in that other situation.
Thank you. That
probably greatly influences how you think about a situation like this. And so I appreciate Mr. Apt flagging that. Mr. Logan, I find there's a factual basis for your plea that if this case went to trial and Mr. O'Gara had to come in here and relive it and talk about it, that with a license plate, et cetera, and potentially the testimony of one of your co-defendants, a jury could find you guilty of all of these crimes. I also find that your plea is knowing and voluntary. Voluntary means that no one's forcing you to do this. You might not be super excited about it, but no one is saying, your family's in trouble if you don't do it or anything like that. And knowing means you've understood the things that you and I and Ms. Dilligard and Mr. Apt have been discussing. Is that a fair statement?
Yes.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that when you're on probation or parole, you may be on both for a while. If you have a minor violation, you and probation will figure out what the results are of that. But if it's more serious, you get arrested again, something like that, that comes back to me. Mr. Apt, can someone in my office sign the indictment on your behalf?
Please and thank you, Your Honor.
Okay, you're welcome. Ms. Dilligard?
Yes, Judge.
And Mr. Logan, we don't hand sign lots of things anymore. We do electronic signatures. Is it okay if we sign the indictment indicating your guilty plea to that reduced charge of robbery and the other crimes?
Yes.
Okay, great. Mr. Logan, I will follow the negotiated resolution in this case, which means as to count one, which has been reduced to robbery, you are being sentenced to 10 years to serve 5 years. You may have spent a little time in custody or a lot of time in custody before you bonded out. You'll get credit for all those days. Those go towards the 5. The balance will be probated. Same sentence for counts 2, 3, and 4. So 10 serve 5, balance probated. Count 5 has to run consecutive to count 1, and it has to be 5 years, but I can probate it or suspend it. I will suspend it, which means the sentence is out there, but there's no probation. You don't have to check in with anyone. But it also means that if you violate the conditions of that suspended sentence, and there's only going to be one, and that's that you obey the laws of Georgia and the other states. But if you were to get arrested during those last 5 years and the state learned about it, they could seek to revoke those years as well. So it's 5 years custody, 5 years probation, 5 years suspended. That gets you to the 15 that were negotiated. Special condition of probation number 1 is no contact with Mr. O'Gara, the clothing salesman. And then number 2, no contact with either of your co-defendants. Do you have any questions about any of that?
No, sir.
Okay. Mr. Apt, anything else on behalf of Mr. Logan?
I didn't quite catch if the court was going to grant first offender or not.
No, you caught it. I didn't. I didn't say that. So that's not part of the equation. Ms. Dilligard, anything else from the state?
Nothing further from the state.
All right. Mr. Logan, you're going to go with Deputy Gordon. Thank you.